Thane has now come to Bangalore because of him. You are saying you should go to Thane.
No, there are two things I'm saying. Bro.
Yes.
I'll place the proposition before your lordships. I understand your lordships have expressed that possibly they are right. But I think your lordship must look at it from a slightly
It's
different
only
point.
a prima
Prima
facie.
facie.
That's all.
Prima facie. Of course, until your lordship decides, I know, my lord, until the last word is said, there's no decision taken. My lord,
It's only an interaction.
yes,
Yes.
I'm going to make my submissions, my lord.
Yes.
When an arbitral award is made, unlike, my lord, when a court decides in a normal civil proceeding, you have to file the execution in the same court, and then you can transfer it. The decree, my lord, at that point in time can be transferred simultaneously to various courts because there may be different properties in different jurisdictions, so each court will exercise jurisdiction. But in arbitration, you don't have to come to the court where the award was made. You can straight away go to a court which has the properties. And therefore, there is no need.
So your submission is today there are no properties here.
No, I'm coming to the next point. The point, my lord, is not that. They can come here as well. They could have come here first. Where you go first is, in my humble submission.
Oh, they have gone to Thane first.
They went to Thane first. They didn't come here first. They went to Thane first. They filed an execution there. They say Thane courts are not good. They're delaying matters too much. We are delaying it. Therefore, courts are delaying it. Therefore, they came here. That's the answer given, my lord. And last time also, your lordship recollect. When I said Thane, they said, oh, they're taking time to file objections. They're not filing objections. There is no, nothing that's happening in
That
Thane.
be utilized for jurisdiction purpose.
That can't be utilized as jurisdiction. That is one. But anyway, my lord, let us assume they can come here as well. Going to a court first has some significance. To which court you go, because the argument advanced and the judgments which they've placed before my lord says, this could be a pre-execution stage. Order 21, Rule 41 is a pre-execution stage in the sense that you are collecting information to decide where to go to, which becomes relevant from the point of view which court you go to first.
So he's already gone to Thane.
That's what I'm saying. He's gone to Thane. If he wants to ask that question as to where your assets are, he must ask that court first. If he asks that court first, because he says it's pre-execution, it is really not execution, but it is pre-execution. If it is pre-execution, the court where you go first, you ask the question. There you get, let's say, details. I have properties in Bangalore. You can then say, I don't want any transfer. You keep this petition here. Or there's no properties in Thane. You keep this petition here. I'll go file an independent petition in Bangalore, independent in Goa and Delhi or wherever. Otherwise, please see the scenario that they're trying to create. They can then say, I will simply go to Mizoram and file an application there and then say, now disclose assets where you are. Because I happen to be there. It can't be. There has to be some nexus to jurisdiction. Which is why I'm respectfully saying, in a case of this kind where you're saying Order 21, Rule 41 is pre-execution and you've already gone to Thane, that is the first court you must ask the question. And then you can go to various courts. You cannot come to court because this court you feel is more convenient for whatever other reasons that you may have. And then say, now give me information as to where your assets are.
What other reasons?
Beg your pardon?
What other reasons?
The other reason is lawyers.
It's fair.
There can't be any other better reason. That's the best reason that can be to invoke jurisdiction. As a matter of fact, lordships know. In Delhi, the intellectual property practice was such that wherever there may be violation, they will bring it to Delhi. Somewhere you find jurisdiction because you want it to be in Delhi.
Yes.
Then, of course, court said you can't come here and then send them to different courts. That's how it ultimately, as lawyers, our duty is to try and get as much work to Karnataka courts.
Oh, that's good. Yes.
Therefore, the point I'm only making is this. While you could have come to Bangalore directly and filed the first execution here, the fact that you've gone to Thane first and filed the petition there will only mean that pre-execution prayer which you could have made could only have been made in Thane. And not having made there and having chosen not to make it
2141 should have been filed
made there first. Because you said you don't know the assets. But the fact, my lord, is they know the assets. In the Thane execution petition, they've obviously identified assets and they've proceeded. But they think that is going to get delayed, therefore they will come to Bangalore. That can't be a justification to come to Bangalore. Therefore, the court's finding that there has to be some jurisdictional element, and here the asset which was there does not exist anymore. And the garnishee against whom he proceeded says, I am not liable to pay any amount to the judgment debtor, has resulted in a situation where the court does not exercise any further jurisdiction. And therefore, my lord, my submission is that the Thane court alone will be the court where they can make this application.
This point also I put down in the submission as to, because the same question came up before the Delhi High Court in the first judgment in my compilation. The court there was dealing with an issue as to whether you should go to Delhi. This is the judgment in Gujarat Hotels.
No, correct. In that case,
Yes.
petitioner there and had already chosen a
Yes, they
forum?
had gone to Rajasthan. They had also filed before Delhi. And in para number 22, the High Court quotes two judgments in Premlata Agarwal of 1970 Supreme Court, SBI versus Indexport 1992 Supreme Court, to say that those rigors that we apply to suits don't apply to executions. You can go to as many courts simultaneously as possible because the interest is you reach the
Execute,
assets.
yes.
And the exception in arbitration cases, which Sundaram Finance and associate contractors have been reconciled, is to say that you have the option of going where the assets are. You have the option going where they reside or registered. You have the option of always going to the seat court because that is the principal court. This is what has come out in these judgments. I've culled out those paragraphs and I've placed it.
All right, Ashal.
So deeply obliged.
Heard so and so reserved. Enter ಮಾಡಿದ್ಯಾ?
We requested the trial court to keep the proceedings continued. Let me give you continue.
To keep the proceedings pending, no, that's all.
ಹೇಳಿದ್ದೀರಾ?
Either.
Yes.
Let can be continued. So deeply obliged.
Yes. Thanks.
Fine.
This is the partial compromise.
Second response.
Partial compromise.
Pass over.
Partial compromise matter.
Yes, pass.